So till now we have covered most of the important points or topics relating to the Constitution of India, and I believe you have kind of uh, improved your learning of Indian Constitution. So from today onwards, I'm going to start a new series on BNSS, that is Bharatiya Nagarik Suraksha Sanhita 2023. And in today's video, we are going to understand a very important section of BNSS, that is section number 18, which talks about public prosecutor. So these are the exact sentences from the barrack. So basically when we say PP or public prosecutor, the normal meaning it states as sarkari vakil who kind of represent the state or represent on behalf of the state. So let's see what are the clauses mentioned under section 18 of BNSS. For every high court, the central government or the state government shall, after consultation with the high court, appoint a public prosecutor and may also appoint one or more additional public prosecutors for conducting in such court any prosecution, appeal, or other proceedings on behalf of the central government or the state government as the case may be. So basically, clause 1 talks about the appointment procedure of PP for every high court. So for whom or for what we will be appointed for, that is for every high court. The central government or the state government. So this shall will make the appointment procedure after consultation with the high court. Appoint a public prosecutor and may also one or more additional public prosecutors. So we have PP, and according to that we have one or more additional public prosecutors for conducting in such court any prosecution, appeal, or other proceeding on behalf, as I said, on behalf of the central government or the state government, as the case may be. So basically the first one point basically talks about the appointment procedures of PP, for whom it will be appointed for and who will appoint it after consultation with whom. Provided that for National Capital Territory of Delhi, the central government shall, after consultation with the High Court of Delhi, appoint a public PP or additional public prosecutor for the purposes of this subsection. So this is for National Capital Territory of Delhi. The same thing it says, the central government shall, again with consultation with the High Court of Delhi, can appoint a PP or APP, that is additional public prosecutor, for the purposes of this subsection, for the purpose mainly to do the functions that is wasted upon a PP or public prosecutor. Let's move into the clause 2. The central government may appoint one or more public prosecutor for the purpose of conducting any case in any district or local area. So this is the area for whom PP will be appointed for, and also it says it may appoint one or more public prosecutors. So it's not like that there will be one only, it can be one or more. And clause 3 says for every district there has to be a PP that will be appointed by the state government shall appoint a public prosecutor and may also appoint one or more additional public prosecutor for the district. As I said, the important thing for of this clause is to remember that for every district there has to be PP, and who will appoint? The state government will appoint, and also along with that PP there will be additional public prosecutor also for the district. Provided that a public prosecutor or additional public prosecutor appointed for one district may be appointed also to be public prosecutor or an additional public prosecutor, as the case may be for another district. For example, if one PP is appointed for one particular district, he can also be appointed for other particular district also. So let's move into clause 4. The district magistrate shall, in consultation with the session judge, prepare a panel of name of persons who are, in his opinion, fit to be appointed as public prosecutors or additional public prosecutors for the district. So who will prepare a list? That is the district magistrate. The district magistrate has the power, but with consultation with the session judge will prepare a list that he will feel that would be fit for the job of PP. He will prepare a list of people appointed as public prosecutor or additional public prosecutor for the district. So only the district magistrate has the power to prepare such a list. No person shall be appointed by the state government as the public prosecutor or additional public prosecutor for the district unless his name appears in the panel of names prepared by the district magistrate under subsection 4. For example, A wanted to be a public prosecutor, but A's name is not mentioned in this proper list that is prepared by the district magistrate, so that person is not eligible to be appointed as PP or public prosecutor or additional public prosecutor. So let's move into clause 6. Notwithstanding anything in subsection 5, where in a state there exists a regular cadre of prosecuting officers, the state government shall appoint a public prosecutor or an additional public prosecutor only from among the person constituting such cadre. So it is basically talking about the clause 5, that if it has a regular cadre of prosecuting officers, then the person can be appointed as PP. From that particular section or people, a PP can be appointed. Provided that where in the opinion of the state government no suitable person is available in such cadre for such appointment, that government may appoint a person as public prosecutor or additional public prosecutor as the case may be from the panel of name prepared by the district magistrate under subsection 4. In case the people uh, in the regular cadre of prosecuting officer is not fit for the job, then the kind of list that the district magistrate has prepared, from that particular list a PP will be appointed. Let's move into explanation. So there we have got this point, or what do I say, term, that is regular cadre of prosecuting officer. So in this explanation note, the definition has been mentioned here, that is prosecuting officer and what is regular cadre of prosecuting officer. So it says means a cadre of prosecuting officers which includes therein in the post of the public prosecutor by whatever name called, and which provides for promotion of assistant public prosecutors by whatever name called to that post. So this is the meaning, regular cadre of prosecuting officer. Then we have prosecuting officers, means a person by whatever name call appointed to perform the functions of a public prosecutor, special public prosecutor, additional public prosecutor, or assistant public prosecutor under this Sanhita. So under this act, any person who is appointed to do the job vested upon a PP is known as the prosecuting officer under BNSS. Now let's move into clause 7. A person shall be eligible. So this may be, or this is talking about the eligibility criteria. A person shall be eligible to be appointed as a public prosecutor or an additional public prosecutor under subsection 1 or subsection 2 or subsection 3 or subsection 6 only if he has been in practice as an advocate for not less than 7 years. So the minimum requirement for being a PP is 7 years age. 7 years advocacy, 7 years of practice. The central government or the state government may appoint for the purpose of any case or class of cases a person who has been in practice as an advocate for not less than 10 years as a special public prosecutor. So this is another criteria which talks about that the person has to be practicing for not less than 10 years as a special public prosecutor, provided that the court may permit the victim to engage an advocate of his choice to assist the prosecution under this subsection. Basically, the state provides PP to represent the case on behalf of the state. In case if the party or the victim wants to bring an advocate of their own, of their choice, then they have the power and they have that thing to appoint such an advocate for their own. So let's move. For the purposes of subsection 7 and subsection 8, the period during which a person has been in practice as an advocate or has rendered, whether before or after the commencement of this Sanhita, service as a public prosecutor or as an additional public prosecutor or assistant public prosecutor or other prosecuting officer by whatever name called, shall be deemed to be a period during which such person has been in practice as an advocate. So it is basically talking about after the commencement of the Sanhita, any person who is been practicing before the commencement of this act, his practice will also be counted as an advocate and in his experience criteria. So that's all about section 18, which talking about PP, who can appoint a PP, who can with consultation of whom, what is the power of the district magistrate, what about a victim when he wants to bring a advocate of their choice. So all these important points I have tried to cover in the video. The section that has been mentioned here is exactly taken from the barrack. So do like, share, and subscribe if you found this video worth watching, so that I can get motivated and I can bring more such legal topics for you. That's all for today. Thank you for watching the video.